You're watching news at Prime. Let's bring you this story now. The Pretoria High Court has reserved judgment in the Democratic Alliance's application challenging parts of the Employment Equity Amendment Act. The party claims that it allows the Labour Minister unchecked powers to set sector targets, which will hinder job creation and stifle economic growth. The DA's lawyer, Xoli Mngambi, arguing that the law is overly rigid and unconstitutional.
The broad submission that we make is that, as is apparent from these provisions, what the Act envisages, the scheme that it put into effect on the statute book, milady, to ensure that the goals in Section 9 of the Constitution were achieved progressively and in a rational manner while balancing, milady, carrying out the necessary balancing exercise that section requires. It envisaged, milady, and required a regime where employers in the first instance were required to address, give consideration to come up with their equity plans, and then those could be monitored and enforced via the provisions I've referred you to by Director General in the first instance and the Labour Court in the second, together with the ability to impose fines. Now, that, milady, we submit was a constitutionally consonant scheme because it set goals, but it did not cross the boundary. And this is a boundary that the Constitution sets, milady, not us. It didn't cross the boundary into a target which is inflexible, which is so inflexible and rigid, milady, so as to, if not be a quota, amount to a quota. And that's why in 014, the notice of motion, we in para 2 want a declaration, if you're with us, milady, and you declare the Amendment Act unconstitutional and invalid, whether in its entirety or separate parts of it, then as a consequence of that, we ask in 2 that any enactments promulgated in terms of 15A be declared unconstitutional and invalid. And that would follow, we say, automatically, because if 15A is not there any longer, it follows any enactment in terms of 15A must fall.
Well, let's get some analysis now. And Labour consultant Tony Healy joining us now to talk about what we have heard in court. Tony, good evening to you and thanks for your time. Let's start with your understanding of the arguments here. What exactly is at play based on what we have just heard?
Yeah, good evening, Xoli. What we're seeing here is we have the DA saying, on the one hand, they're not opposing the need for there to be some affirmative action measures in law. However, they believe that the proposed amendments to the current Employment Equity Act go too far in that they move from a position whereby employers themselves would set numerical targets to achieve affirmative action measures. It moves from that position to a position where the Minister of Employment and Labour now has the power to set numerical targets that they believe are quotas, and they believe that to be grand social engineering and overstretching and unconstitutional.
Yeah. If we follow the thinking of the Democratic Alliance for a moment, Tony, Helen Zille holds the view that if the law stays as it is, this will drive unemployment up and further decline the economy. Is there a direct correlation between the Employment Equity Act, the very section that has since been introduced, and the employment, or should we say unemployment crisis in the country?
Look, it's hard to say, Tony, that that would be the case. I mean, there's certainly an argument to be made. The two sides of the argument are essentially this. The Department of Labour is saying that the affirmative action measures in the current version of the Employment Equity Act have simply not achieved the affirmative action goals where you have a workplace that is generally reflective of the demographics of the country or the province, in that, for example, still in excess of 62% of all senior positions are occupied by white males. The Democratic Alliance, on the other, and therefore they need to set these numerical targets. Department of Labor would also say, you know, if you can justify why you failed to meet these targets, no problem. The DA is saying, well, it's not that easy. The minister has these sweeping, ambiguous, vague powers, which could, if they view an employer not to have achieved these targets without a valid reason, could, for example, result in a really prohibitive fine equal to 10% of annual turnover, not 10% of profit, 10% of annual turnover.
You invoke this argument also about the sweeping powers of a minister. Today, a ruling from the highest court in the land, the Constitutional Court, coming out to say that the Minister of Home Affairs and their powers to grant permission for anyone who holds a citizenship outside that of South Africa, that person would basically first need to get the minister's express permission before they become citizens of another country. If that has not been done, that person automatically loses their citizenship of South Africa. Is this a little ominous for what is being argued here, the sweeping powers of a minister?
Look, I think at the very least it's cause for concern. And I did see the dual citizenship Constitutional Court judgment today. Coming back to the Employment Equity Act, I think the difficulty here is that no one argues against, in principle, the fact that there need to be affirmative action measures to address past injustices. The DA accepts that. What they're saying is the minute these numerical targets, they argue, are akin to quotas, rigid quotas, and the penalties associated with not achieving them are enormous. For example, you would not be able to do business with any sphere of government, nationally, provincially, or at local level. And as I say, you run into the potential at the whim of the DG or the minister, if they believe you've not achieved your targets without valid reason, really extremely punitive penalties of 10% of turnover. So, you know, one tries to look at this objectively because it's such a heated emotional issue. But I do think that the DA there's merit in the DA's argument that this is ministerial overreach.
Finally, Tony, the South African situation remains, as you initially quoted, those very statistics. 62% of senior positions in South African companies still held by white males. Is there good reason for why the Employment Equity Act should remain in place, though?
Well, I think a solution or a way of dealing with that unacceptable percentage is to execute the provisions of the current or the pre-amendment Employment Equity Act more efficiently, because I think therein lies the rub. And it's so true, I think, in so many areas of our law. We have legislation, we have statutes, but when it comes to implementation and monitoring and assessment, the resources are not available to, you could even say the same about SAPS. The resources are simply not there. The number of labor inspectors just simply don't exist. I think if you kept numerical targets to be run by employers themselves and hold them to account more rigidly with greater enforcement, that you have a fairer and more realistic potential of achieving the objectives that affirmative action has in the first place, to have a workplace that mirrors the demographic of its environment.
Tony Healy, thank you very much for your time and analysis tonight. Tony Healy is a labor consultant talking to us from Cape Town.